Okay, so now we're going to call page 14. Page 14, Miles Hunsworsen versus Affinity Lifestyles et al. Case 831543 and consolidated cases. So let's go through counsel and see who we've got on the line. On behalf of plaintiffs, who do we have, please? I believe we do have some counsel for plaintiffs, please. Would you like to make your appearance? We saw in the chat somebody did put their name.
For defendant.
Counsel, I believe we had someone. So from the Kemp Jones firm, is there somebody? I believe they put their name in the chat or told us. Anybody for plaintiffs? Pepperman, is Eric Pepperman on the line or someone from?
Your Honor, this is Laureen Frister for WFM Southern Nevada. I can explain why Eric Pepperman is not on the line. The parties stipulated
Well, hold on a
to
sec, counsel. Let me see who else, please, is on the line.
Okay.
Because we all told you all, remember, you don't submit a stipulation in accordance with the EDCR. The hearing needs to go forward, right? So give me 1 second, please. But let me see who else is on the line. So we do not have anyone from plaintiff's firm. No one from Kemp Jones.
Your Honor, this is Don Springmeyer from Kemp Jones, but I'm not on the affinity case.
Okay, you might want to reach out to one of your colleagues if they wish to make an appearance for today's hearing. Okay, no worries. I'm going to circle around to the rest of the parties, then we'll come back to you. So let's go next, please. Thank you so very much. Okay, next, let's go to Milwaukee Instruments. Any from Milwaukee Instruments?
Good morning, Your Honor. Elizabeth Lowell for Milwaukee Instruments.
I do appreciate it. Thanks so much. Costco Wholesale, please. Michael Federico or somebody from Costco? No one. Okay. Let's go to ETT1 LLC. Do we have anyone from that? No? Okay. How about Real Water?
Good morning, Your Honor. Joel Odou from Woodsmith, Henning, and Berman on behalf of both Real Water and AffinitiesLifestyles.com, Inc.
Okay, do appreciate it. Thanks so much. On behalf of Whole Foods, please. Okay, currently lists no attorney, but we thought there was an attorney. Okay.
Yes.
And
this is Laureen Frister for Whole Foods.
okay, that's what I thought. Okay. Okay, so, and we have then the rest are cross claimants, cross defendants, third parties. The only new third party we see is Nevada Beverage. Anybody else from Nevada Beverage? No one on behalf of Nevada Beverage? Okay.
Colt Dodrill, bar 9000 for Nevada Beverage.
Okay, thank you. So, counsel, today is the day that was set for defendant Costco Wholesale's, well, it's joined, but let's start first with defendant WFM Southern Nevada Inc., DBA Whole Foods Market, motion to dismiss and motion for a more definite statement. And we have defendant Costco Wholesale Corporation's joinder to defendant WFM Southern Nevada Inc., DBA Whole Food Markets, motion to dismiss and motion for a more definite statement. The court is aware that there was the court is aware that an initial potential stipulation was submitted to the court that did not comply with the EDCR. Said stipulation was then returned, and all parties notified that if there was not a proper stipulation in accordance with the EDCR, the motion would need, in a timely manner, right, the motion would need to go forward, the hearing need to go forward, because in fairness, as we note, you have several other parties on the line, right, and they would not have had sufficient notice or any reason to know that something was going to be continued. So then this court's understanding, and the court cannot address any ex parte communication thereafter, after even notifying the parties, since they did not respond after the rejection memo, and this is that the proposed stipulation was not in accordance with the EDCR. The court never received a new stipulation timely to our order inbox as required by the administrative orders as well as by the EDCR. Instead, this court's understanding is someone tried to send an email around 4:24 p.m. yesterday that didn't in any way comply with the administrative orders. And so therefore, this hearing was left on in fairness to all the parties that had scheduled it. And since there was no appropriate notification. And as you can also appreciate, as you know, as a matter of public record, there was also a media request that was granted for today's hearing. So in fairness to everyone, we had to keep the hearing on because there was no timely and appropriate stipulation to continue it. So I don't know why I have no one for plaintiffs. We'll try one more time, please. Do we have anyone counsel for plaintiffs? No.
Your Honor, this is Don Springmeyer. I sent an email to Eric, and that's all I can do at the moment.
Sure. Mr. Springmeyer, can you speak a little more loudly? I can barely hear you, and I do not think it probably came through to our court recorder.
I'm sorry. I said this is Don Springmeyer from Kemp Jones. I've sent an email to Eric Pepperman without getting a response. That's all I can do at the moment.
No, I appreciate you're not on this case. It's just we saw that, well, I saw you logged in on the chat, and since we're from the same firm, I didn't know either A, maybe you might be covering it, or B, you might have some information that there was some kind of emergency or something that the court may not be aware of. At this juncture,
I'm afraid I don't have either of those rationalizations, Your Honor.
Sure. No worries. We just want to make sure everything's, fair and accurate and properly noticed. So at this juncture, I think counsel for Whole Foods, you wanted to say something, so I'm going to let counsel for Whole Foods please speak. Go ahead.
Thank you, Your Honor. This is Laureen Frister for Whole Foods. We
Can
did
you speak
receive.
louder so we can hear you, please.
Okay. Are you able to hear me better now?
Madam Court, can you hear better now? Okay, now she can hear you. Thank you so much. Go ahead, please.
Okay. Thank you, Your Honor. So yesterday at 11:39 a.m., there was a notice sent from your chambers notifying us that the stipulation order was rejected. However, I didn't receive it at that time because my email address was entered incorrectly. When I did receive an email from your JEA, I informed her that I would immediately obtain the signature of Mr. Federico, who is counsel for Costco. Costco filed a joinder to this motion, and unfortunately I wasn't able to get a hold of him until the very end of the day and get his approval. So that was me that submitted a revised stipulation order at 4:24 p.m. and I apologize for sending it to the JEA. We were corresponding and I responded to her email, so I apologize for that. Mr. Pepperman and Mr. Federico were aware that the stipulation was submitted at 4:24, and that's why they're not here today. And we won't go forward. We would like to not go forward today with the motion.
Okay. Counsel, as you can appreciate, a couple of different things. Remember, the EDCR right applies to all cases, all aspects, and you have to submit a timely stipulation, right? For all interested parties, as we stated in the rejection memo. The rejection memo, realistically, just to give you another heads up, is the issue may be that you may not have made a proper appearance because under Whole Foods defendant, it says no attorney on our Odyssey records. So remember, you only get e-served at the email address that you put into the electronic filing system. It's not something that we would have. Huh? Okay. Sure. And okay, so also remember you've got the Tuesday. Let's go a little bit clearer. I think you're missing something because you all did not even submit your first order until Tuesday, September 28th at 11:26, and that was the improper order, right? So then that order was timely rejected because it did not comply with the EDCR, and not only would you have gotten the email left side filing of that on Tuesday evening, but you also would have gotten it through the Order in the Court app, the return notification. So that would have been on Tuesday. So then by the time you sent something else, and then we followed up with an email to all parties so that had submitted said stipulation, because that would be the appropriate thing to do. And in that regard, that was sent at 11:39, and then the second one, just in case, at 11:40. And so that does say that yesterday received a attached stipulation order to continue the hearing and briefing schedule. However, it was rejected. We sent you another copy of the rejection memo because all parties, it was underlined, all parties had not signed off, and it was returned to the submitter. Court's inquiring whether or not the parties will be submitting a compliance stipulation in order to continue tomorrow's hearing, or if the hearing is going to go forward or not. I called and left a message this morning, so I'm following up with an email just in case someone didn't get the message. And so we said, please let us know. We did not receive anything until that 4/24, and you can't send an email. As you know, the administrative orders, EDCR 7.21, all require that it must go appropriately to the order inbox. We cannot have any ex parte communication, and even what was submitted was not compliant. It did not have the email authorizations or any electronic signatures of any of the other parties, nor did it include all parties as noted and as required right under the EDCR. So appreciative of what you're saying, but remember, attorneys do need to appear unless you actually get a court order saying that the hearing is continued under the EDCR, and it does specifically say it can't be continued less than one judicial day for the very reason that you have several other attorneys, right, from several other of the parties in this case, and they would have needed to have gotten all appropriate notifications. So, counsel, it's WFM's motion, but I'm not sure what you're really asking at this juncture, nor do I know what the other parties wish to have happen, because I've got them on the line, but I don't have the party that opposed the motion, nor do I have the joinder party, nor did this court grant that, because I couldn't have granted it because the EDCR precluded it, and we didn't have anything timely provided. So hopefully in my giving that long explanation, I maybe have given a chance and a time that maybe even late. And remember, we've now got everybody else waiting in all of our other cases for this. So let me check one more time. Do I now have counsel for plaintiff on the line? No, nobody else from the Kemp Jones firm. How about counsel for the joinder party, Costco Wholesale? No. Okay, well, counsel for Whole Foods?
Yes, Your Honor.
What are you suggesting that the court do at this juncture in light of, this is the set hearing, the court's obviously all prepared, I've read everything. I have all sorts of other parties on the line whose clients are spending their right costs and expenses for them to be here for the hearing. So what are you suggesting the court do, counsel, please?
Well, Your Honor, the reason for the stipulation in order to move the hearing is because I will be withdrawing as counsel, and new counsel is going to be substituting in shortly. In fairness to all the parties, we respectfully request that the hearing be continued to November.
The stipulation didn't mention anything about any withdrawal of counsel.
I know, Your Honor. I'm waiting for paperwork and for new counsel to contact me and get back with me, but I will be withdrawing and new counsel will be substituting in.
Okay, well, let me check with everybody else on their position because they're here as well. So Milwaukee Instruments. Counsel, can you state what's your position, please, since you're on the line? Counsel, go ahead, please.
Yes, Your Honor. This is Elizabeth Lowell from Milwaukee Instruments. I have no objection to continuing the hearing so that new counsel can be retained and get up to speed.
Okay, counsel for Real Water, please. Your position?
Good morning,
Real Water
Joel
and Infinity
Odou.
Lifestyles, please. Thank you. Go ahead.
Joel Odou on behalf of Affinity Lifestyles and Real Water. No objection, and we would join in the comments made by other counsel.
Okay, counsel for Nevada Beverage. Your position, please.
We have no objection to the continuance.
Okay, remember we need you to state your name, please, each time you speak. We've got lots of counsel on this case, so we just get a nice clear record for you, please. Counsel, can you repeat it with your name?
Of course, Colt Dodrill for third-party defendant, Nevada Beverage. We have no objection to the continuance.
Okay. My challenge here is, of course, I don't have the position of the very opposition plaintiff's party. Let's see, Mr. Springberg, I'm not forcing you to speak in any manner whatsoever, but if you happen to have anything you wish to say, I'm giving you the opportunity, but you can easily say that you're not counsel on this case. You don't wish to state something. It's just, I'm giving you an opportunity if you wish to. Go ahead, please.
Thank you, Your Honor. Don Springmeyer. I'm sure I'm capable and willing to agree to the continuance. So we do on behalf of the plaintiff.
Okay, no worries, thank you. Well then, let's try one more time. Do I have Councilor Costco? Mr. Federico, one last chance, please? Okay. So in that regard, since I have at least the movement, and the movement is requesting, and there's no objection from all the parties that did appear at the properly noticed hearing to continue it, the court's going to take it off calendar, and then it's going to need to be refiled, right, with a new date so that all parties get appropriate notice. Does that meet the needs of Counselor for Whole Foods, or are you requesting something different? Go ahead, please.
Thank you, Your Honor. Are you ordering Whole Foods to refile the entire motion, or to file a notice for a hearing or a request for a hearing?
Well, I'm not sure which way you were specifically requesting, so I understood you didn't want it to be heard today. So what are you requesting, please?
I'm requesting that the hearing be continued to October 26, 2021 at 8:30 a.m.
Okay, we cannot do that, and I'm sure you can appreciate we actually are in trial. Unless you tell me that this case is going to take just a few moments for oral argument, we have to have full trial days pursuant to the administrative order. And so while I can do an 8:30 hearing, I'm glad to do those, and we already have some set on that day. If there's going to be limited argument, about 10 minutes, 15 minutes total, that would be fine. But if not, then the 26th would not work because of the fact that I'm scheduled to be in a jury trial, right? And so under our COVID protocols, we can do hearings before trial starts, but we're supposed to be starting trial so that they have the full days to minimize the impact to our community, those individuals serving as jurors, as well as the counsel that would be there as well.
Your Honor, then we respectfully request that the hearing be continued to the next available date that is convenient for the court.
Okay, that's the reason why you're going to need to send some kind of notice, right? So why don't you coordinate with everybody, okay? And submit to the court a new date that the parties are going to request on a Tuesday or Thursday at 8:30, and then give us an estimate of how much time you need. If you don't need, like I said, if you only need about 10 or 15 minutes, we can put you on the 26th. But if you think it's going to take more than that for oral argument, then we would need to know so that we don't impact that jury trial. Okay?
Understood, Your Honor.
Okay, so for this juncture, we have to take it off calendar since we don't have a new date to put it into. You just take it off calendar, and then we need to submit an appropriate stipulation in order as to what date you would like that hearing to be. And please do submit in the stipulation the amount of time you need for oral argument. Okay?
Understood, Your Honor. Thank you.
Appreciate it. Thank you so much. Is there anything else the court can do on case 831-543, Hans Warson versus Affinity Lifestyles for any party?
Yes, Your Honor, briefly. This is Eric Pepperman, counsel for the Hunwardson plaintiffs. I apologize. I thought from the prior stipulation this hearing was off, but I agree with counsel that we'll stipulate to find a new date that works for the court. I just wanted to make my appearance known.
Okay, do appreciate it. So Councilor Plaintiffs making an appearance at 8:53. Okay, thank you so very much. Then that would conclude all matters on Hans Warson versus Affinity Lifestyles et al. And we're going to move on. Thank you so much. Okay.